Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at an excellent book which I found fascinating because I'm involved in this area of law and have been for the last 35 years. It's actually dealing with comparative labour law, in other words employment law, whatever you want to call it, industrial relations law, but it's looking at it from the view of a number of different countries. It's been edited by two people, Matthew Finkin, W. Finkin, and Guy Mundluck. And the book has come to us from Edward Elgar Publishing Limited. They are an excellent high end user level of publishers for legal research materials, useful for both practitioners and of course for those involved in higher academic work. This book is part of a series from the Research Handbooks in Comparative Law. Now, my wife Elizabeth and I talked about this book because we thought it was again a very interesting one to have a look at. And the review of the book, we've given it this title: Emerging Trends in Employment and Industrial Relations Law Across a Range of Jurisdictions. Now, before I talk about the review itself, here is the book. It's quite a heavy book actually. It's a hardback. There we go. Spine, and then the back. You've got all the usual stuff at the back. As I say, it's part of the Research Handbooks in Comparative Law there. Series editors are Francesco Parisi and Tom Ginsberg. Now, the book itself runs to something approaching just under 500 pages. There's an index at the back. It's on page numbering. It's not paragraph numbering, you'll be pleased to hear. Then after the index, you've got the actual text itself. You can see here you've got a certain amount of paragraph numbering, and you've got footnoting all the way through. And as with all these books, this is an edited work, so they're contributions. You do have a nice structure of the introduction, the meat of the arguments, then a little conclusion, which I do think is helpful. Now, here's the comparative law front page, and that's the series that it makes up part of. You can see they're very high end users. Some very nice dedications there, which I always like to mention. And also, if you're interested in the online system, the detail for that is there, and it's available. Let's just see, it is available as an e-book as well. Now, the list of contributors, we'll go through those in a minute. There's the front of it with the various part numbers, with chapter headings, 3 parts in total, 14 chapters. There we go. Then you've got the list of all the people involved. It's a pity they haven't got a bit more information about the contributors, because these guys put a lot of a huge amount of work into it. You can see how many of them there are. But they've brought together people from a whole range of jurisdictions, which I think is very, very helpful. The introduction, well worth reading. There's no preface, so the introduction gives you some idea. We begin with a rumination on the organic nature of law. Law has a shelf life. As the society in which law is embedded changes, parts of the law wither away or become vestigial. I'll get it right. Parts are extended or renewed in novel application. New law is fashioned whole to commence the life cycle afresh. Lovely imagery there, but you see where they're coming from quite quickly. And the tone of the writing. Now, if we just go into the book itself, Regulation of Labour, the Legal Origins Theory. So you've got quite a lot of information as the book develops about where the book's coming from and the direction it's actually going in. Very interesting book. As I say, I think you've got to have quite a lot of knowledge to understand some of the stuff they're talking about here. But as with all of the Elgar books, when you do read them, you amass a lot more information, because what they've brought together is a splendid series of views and possible conclusions about the way ahead, which I always think is helpful. So this is what we said. In fact, I'm just going to repeat a little bit of what's the introduction. They said, the two editors, law has a shelf life. It presents a wide-ranging study then, this particular book on law, of, as is generally referred to in the United Kingdom, employment and industrial relations law, which is coming from an international perspective, assisted by learned dissertations from no less than 37 international contributors from top universities worldwide. Now, if you want to call it labour law, it doesn't really matter. I mean, we have changed the terms depending on who's in government and various other things over the years. But whether it's labour law, employment law, industrial relations matters, whatever, we know basically what we're referring to, and that is the law relating to people in the workplace and the relationship between the managers and the workers, if I can put it in that crude terminology, in England and Scotland and Wales and Northern Ireland. The thing is, it's different overseas, so therefore you have a different structure, but you still got the workforce and the people running the businesses, or the organising the public sector organisations. So you do have that matter, and of course you have, because I mentioned industrial relations, you have trades union law as well, all of which is embraced. Now, having said that, law, as the editors remind us, is an organic entity, remember the introduction, ever responsive for the most part to change, and that's where it should be. This book is, and jurisprudentially I would hasten to add, this book is aimed obviously at comparative lawyers, as it brings together any amount of fresh thinking on the subject of labour law across a wide range of jurisdictions in an era when global business has become the norm. And I say that because when I first became involved in this 40 years ago now, the concept of labour law was so different, because we were very, very insular, whereas today you just go to the City of London, you see the huge number of international companies, and you get some idea that business is totally different. There may still be the views about whether we should have nationalised industries and so on, but the basic principles have changed quite dramatically, in that the likelihood of you being employed by someone who is from a company in a different country is much more likely today than it was when I first started working in 1970. So you get some idea of what the changes have been in 45 years. Labour law, or industrial relations law if you prefer to call it, whatever you want to call it, has only become a legal specialism in the 20th century. We did have other versions of it if you go back into the history books and legal history books, but you've got a master-servant relationship. You've got all the wrong words and all the problems associated with rather a different type of society and different aspirations. So today it's of course most relevant and important in industrialised economies where there's a substantial workforce or bureaucracy or both to have your laws in place. Generally these are countries with free market economies or countries making the transition to the free market. It's pointed out in the study that labour law, just about anywhere you find it, is a young discipline, and that's right. Such a study will reveal a variety of value systems and varying standards as to the ways in which people, specifically members of a workforce, are treated. And part one of the book is split into various parts. In particular, analyses and comments upon the nature and wisdom of this comparative task, while at the same time laudably resisting the urge to jump to conclusions about which system is necessarily the best. We then move on to part two. The contributors tackle a number of areas of special concern to comparative practitioners, such as freedom of association, a very important one, that's the right to be a member of a trade union. Collective bargaining, that's a relationship between the managers and the unions when it comes to getting money. Discrimination, job loss, and the nature of the employer, as well as employee dignity, autonomy, privacy, and social inclusion. And, I would add, diversity. Part 3 includes regional comparisons with reference to European Union labour law, transitions to the free market economy in Eastern Europe, and similar or divergent developments in the BRICS nations. Can I just say here, remember within the European Commission that this is looked at as a sort of social policy to a certain extent, which is, I think, right, and therefore that's how it is actually structured within Europe itself. And we have to look at it on that basis because of the effect it obviously has when you have a set of labour law rules as they affect both the workforce and the management. With detailed footnoting throughout then and a handy index at the back, we found that this book is a time-saving research resource offering practitioners and students alike a variety of sometimes novel and certainly important perspectives on international labour law, and I welcome it. I think this is an important area, especially as we see the way that the European Union is going to change in the next few years. I'm recording this in 2015. We've got a lot to look forward to. UK lawyers then dealing with difficult trades union issues will find many of its constituent articles quite illuminating. And I think this is going to be an important issue. We've just had the election of a Labour leader who's very left-wing, Mr Corbyn, in Britain, and the trade union issue, which has hitherto been very, very low on the political agenda, could well raise its head quite significantly. So it's something to bear in mind, together with Mr Corbyn's anti-European Union stance and the fact that we will have a referendum probably in 2016 on whether we continue as members of the EU, and all the things that could happen if we don't, although my view is we will stay in. The publication date of this book is 2015. It's an excellent title. I found it great fun. But I love the subject, of course, being involved, having been a trade union leader, negotiator, and of course a lawyer. There's the front, side and the back. There's a nice quote from Bob Heppel, who's just died recently. So Bob Heppel QC. It's a very nice quote about this book, which I found rather touching, having just seen his notice of his passing. Now, the lasting influence of legal origins. Very interesting title. Just wanted to show you. It's the middle of the book here. Again, you see the number of people involved. The structure is you've got the names of the people, you've got an introduction, footnoting and everything else. The lasting influence of legal origins, workplace discrimination, social inclusion and the law in Canada, US and the EU. So you really have got an international flavour to it throughout, which I think is very important, because these books will be very, very, very important, persuasive books, I think, for the future, as we see the new generations coming into work and we see totally new views as society changes. I'd like to thank all concerned, the authors, Edward Elgar in particular, because they really do come up with some great works for us to use for research purposes, and they help the debate. They also are useful for practitioners too. If you've got a real case and you want to have just a slightly different approach to it, have a look at some of these books because they're worth reading. Thank you to all anyway. Bye bye.